Good morning to all of you. Today we are going to discuss the topic assault. Actually, assault and battery they have to be clubbed and told to you. But anyway, let us know what is assault. Assault is as a tort, please remember. So assault and battery they can be used in the tort law as well as in the criminal law also. So now we are advancing. Previously I told you that the torts they are only civil wrongs. Now we are taking them to the criminal side also. But so assault means the unlawful laying of your hands on another person. The unlawful attempting to use criminal force on another person, or any gesture or show of force made by you which makes the other person think that or apprehend that you are likely or you are about to use the criminal force, it is called assault. In assault, actually there is no physical touching, just clenching your fist. Yes, that itself is an assault. Right? So, very simple thing in tort law, of course. Tort law discusses only very simple things. So please remember, according to Arnold, Chief Justice actually, he explained any gesture calculated in the party. So a reasonable apprehension that immediately some violence is about to be used. This is the definition given by Chief Justice Arnold C. But whatever it is, please remember. So if there is any force or any gesture calculated to excite the other party that you are going to offer violence, it is called assault. So please remember, it is nothing but unlawful laying of hands. Already I told you, right? So what are the essentials? The essentials for the assault are: number one, so it is an attempt to do a corporal hurt. Corporal means personal or to the body. Second, the intention, of course, the intention may be necessary or may not be necessary. The intent itself will make the assault. That means, suppose if I look at you with open eyes, so it is an indication that I am going to assault you. I did not do anything. I did not even speak a word itself. So you are able to read my intention, right? It should cause the apprehension that the other person is about to use the so-called violence or force, right? Then examples also is given. Threatening a person with a loaded pistol, definitely. So for extortion or for kidnapping, whatever it is definitely an assault. Showing fist in a threatening manner, already I told you, the clenched fist, yes, itself is an assault. Or one person tries to hit the other but he misses. So you are trying to hit him, but as a defense shot he misses, but it is also assault, right? So then one person holds up his hand against the other but says nothing, just he will be holding his hand, or so this is also assault. So please remember, these are the examples of assault. So which are not at all also as given. A strikes B upon the hand while traveling in a bus. Suppose you are traveling in a bus, you hit him, you just give me side. It is not assault. This is an exception, right? Now likewise, A threatens B with an unloaded pistol, which knows. So B knows that is an unloaded pistol, A threatens with it. What happens? Nothing. It is not an assault because both of them know that it is unloaded. It cannot do anything, right? Then A is traveling in a moving train and B likes to throw water on him, right? It is or stone, likes to show a throne that he is about to hit him with a stone. Yes, definitely it will be an assault. Please remember, right? Mere words do not amount to an assault, right? However, if words create reasonable apprehension that you are going to use force, definitely it will be assault. So there are two case laws which are more important and you must remember them. Old cases, but anyway, good to remember. The first one is very famous, Stephen versus Myers, 1830, yes, exactly. Stephen versus Myers. So actually, Stephens was the chairman of a parish, some Christian organization. So they were holding some meeting with all the members. So Myers is opposed to him. So Myers is interrupting in the talks quite often, and he wants to go near him, and ultimately a stage has come where Myers was with the intention of pulling him down. He went almost near to the stage or to the chair. At the time, the persons around Stephen, they removed him and they booked a case of assault that Myers wanted to pull him. Meyer made a show that he wanted to pull him from the chair, which is an assault, and the court has accepted. Second case is Balisetti Venkata Surya Rao versus Nandipati Muttaya, maybe in the year 1964. This is another celebrated case. So Balisetti Venkata Rao was an agriculturist. He was in a village. In Nandipati Muttaya Chaudhary, Muttaya is actually the village munsif at the time. Now present days we call him as a VRO. This VRO went to the village to collect the revenue cess or revenue cyst. Balisetti Venkata actually was due some amount to the revenue department, but he was not able to pay the money at that particular point of time. Now, the VRO, that is Nandipati Muttaya, or the defendant, using his powers as the village magistrate, he wanted to attach certain property. Incidentally, the property what he has chosen was the earrings to the ears of Mr. Balisetti Venkata Surya Rao. Yes, he is competent. So he said, I am going to take away your earrings. Then he called the goldsmith also. Goldsmith came from the village, of course, from some point he came, and at that particular point of time, since it had become an embarrassing position for Mr. Balisetti Venkata Surya Rao, some other relative or another villager, he brought the money and paid on behalf of Balisetti Venkata Surya Rao. The matter went there. But Balisetti Venkata Surya Rao, offended by the threats or by the activity of Mr. Nandipati Muttaya, then he filed a case of assault. But court did not agree. The court stated that, number one, the VRO or the village municipal has got authority to attach the property. Even then, Nandipati Muttaya, just in a fit of showing his power, he said that he will attach the rings, and he called the goldsmith also. But the goldsmith did not do anything. He did not make an attempt. There is no gesture on the part of the so-called goldsmith or on the part of the VRO to remove the earrings. So no assault has been committed. So it is a negative example. So I think with these two examples it is sufficient. Please, so remember definitely assault. You will definitely get a question either on assault, battery, false imprisonment or malicious prosecution, which we are going to discuss in further. Thank you.